AmTrust Europe Ltd and Endurance Worldwide Insurance Ltd and others.
Good morning. I appear in this appeal with Mr. MacDonald. Mr. Hopkins Counsel and Mr. Archer appear for the respondent, AmTrust, Sompo rather. You've seen this is an appeal against a decision of Peter MacDonald Eggers, King's Counsel, sitting as a deputy, when he refused to direct the two issues for disclosure be included in the disclosure review document. And the effect of his decision was striking. It means that the trial judge hearing the 5-week trial in November will determine the scope of cover provided by an insurance policy without seeing all the terms of that policy. And it means that two parties will be arguing over the meaning and effect of a contract, and only one of those parties will know all the terms of that contract, so the parties are not on an equal footing. And the decision may mean that AmTrust recovers nothing from Sompo, rather than the sum of about 65 million. You've seen that permission to appeal was given by Lord Justice Males, and when he gave permission to appeal, he suggested that Sompo should consider whether the more sensible course would be to provide the disclosure rather than resisting this appeal. No doubt Sompo carefully considered that suggestion, and one would expect that it would have considered the documents and considered whether they were damaging to its case. In any event, it's decided not to give any disclosure, but to fight this appeal, including filing a respondent's notice and 2 skeleton arguments. And the likelihood is that it's spent more resisting this appeal than it would have cost to review the 2 underwriting files and provided the disclosure requested. And it's only natural that that increases the suspicion on our side that there may be something in this document which is helpful to our case and damaging to Sompo's case. So with that introduction, what I propose to do in my time available is to summarise the background and take you to a handful of the key documents. Second, to identify the question for the judge and what the judge decided. And thirdly, to tell you why the judge's decision was wrong.
Yes, we have obviously read the papers carefully. We are pretty sure we understand the background. The points are, in truth, pretty narrow, and are the points that you you made in your introduction. I'm not inviting you to sit down, but I'm encouraging you to follow that programme, but fairly economically.
That's a very helpful indication. Always puts one on a horse's dilemma. If you're too short, you think, "Oh gosh, why didn't I take longer?" And if you're too long, you think, "Why am I wasting?"
No, you got it. You've all right so far, Mr. Arlington.
Excellent. Good. Well, I will take it as read that you understand the background to the fundraising scheme and the involvement of the parties, and the fact that the way it's structured, ordinarily AmTrust would be bringing its claim against the solicitors, and the solicitors would then be bringing a claim for an indemnity against Sompo.
Yes.
But because the solicitors have gone into administration, there's been a statutory transfer, and so it's now us just bringing the direct claim against Sompo.
And in the if it had been the original parties rather than the assignees, absent very unusual circumstances, they would have access to exactly the same contractual documents as
yes.
As the respondents, but not in your case.
And not in our case. And it's that statutory assignment that sort of puts us in this invidious position.
Yes.
That we're pursuing rights under a contract without knowing all the terms of that contract, which is an unusual position to be in. And disclosure, of course, is one of the key ways to put the parties on an equal footing. With your lordship's helpful indication, let me just take you very briefly, if I could, to the TOBA.
Yep.
And that's really for 2 reasons. Firstly, to identify why the documents to be disclosed are relevant to the issue in the case. And second, to just tee up the fact that the authorities that Sompo relies upon to resist disclosure don't support its position, because this is a case where we have an 80 insurer bringing a case against solicitors who it engaged to provide services for it. And such a claim is not considered in the authorities. We do have authorities dealing with cases where you have litigation funders or lenders bringing claims against solicitors, but no comparable case to this. And also I want to touch on the policy wording, because again, the policy wording here is materially different to the policy wording that's been considered in the cases, and it's wording which is significantly materially wider than that required by the minimum terms. So let me just take you briefly to the TOBAs, which are in the core bundle at tab 20. And the one with HSS is at tab 20, the one with Pure is at tab 21. They're in the same terms, so I'll just take you to the one at tab 20 with HSS. And the AmTrust case is that the solicitors breached the terms of their TOBA, so there's a claim brought in contract. It's also AmTrust case that the solicitors owed a duty of care at common law, and so there's a claim pursued in negligence as well.
Yeah.
So we have the TOBA at page 309, the front page of it, and it's between CLE, which was the agent acting for AmTrust, and the scheme solicitor. And if you just look at recital 3, whereas the effect of this delegated authority scheme is the scheme solicitor solely responsible for risk assessing the merits of each personal injury claim, which removes the need to submit a detailed proposal for each claimant. And the scheme solicitor therefore agrees that it will carry out a full and detailed risk assessment and will provide the administrator and the insurer with a professionally reasonable assessment of the prospect of success of each claim it proposes for after the event legal expenses cover. Because by writing ATE cover, of course, AmTrust was exposing itself to the risk of a loss, having to pay out adverse costs if the claim failed, having to pay disbursements if the claim failed. So this was a mechanism by which effectively it was making sure it wasn't writing a load of rubbish, it wasn't underwriting a load of bad cases. And thus there was an obligation on the solicitors. Recital 5, the administrator agrees to accept business on behalf of the insurer who will underwrite those ATE risks on the basis such claims are being pursued by the scheme solicitor by way of a CFA, standard retain or any damages-based agreement, and are reasonably considered to possess the prospects of success stated by the scheme solicitor in the application for ATE cover. And 6, for the purpose of this agreement, the administrator is contracting on behalf of the insurer. So it's contracting on behalf of my client, AmTrust. And then if I just take you to 3 clauses, please. The first is over the page at 310, clause 1.1. The scheme solicitor will ensure that all declarations made when applying for cover via the administrator are entirely accurate and reflect the risk being proposed to the best of the scheme solicitor's knowledge, belief, and professional opinion. So here are solicitors undertaking obligations to AmTrust.
Excuse me.
1.4, once an ATE policy has been issued, the scheme solicitor must ensure that the policyholder complies with all of the stated policy terms and conditions, which includes but is not limited to the scheme solicitor immediately notifying the administrator of any material change of fact that's likely to affect the prospect of success of the claim. And then there are other things that has to do as well. So more obligations that the scheme solicitor is owing to AmTrust. And then at 1.10 over the page, the scheme solicitor understands at all times it has a duty of care to the administrator and the insurer. So express provision that the Pure and HSS.
I'm sorry, that last clause was?
1.10, I'm sorry, at 311.
It's my fault. Thank you.
An AmTrust case is that Pure and HSS breached the contractual and common law duties that they owed to AmTrust. I needn't take you through the particulars of claim and can summarise Sompo's defence in this way. It contains 2 parts. The first is to deny that HSS and Pure were in breach of any duties. And then secondly, to say, well, if they were in breach of any duty, then they weren't entitled to any insurance cover because the policies don't respond. the policies do not provide an indemnity for such liabilities as it's found are owed by the scheme solicitors to AmTrust. So whereas our case is that Sompo is obliged to pay it already 15 million for sums already paid, and a further 50 or so million if Novitas's claim, the upstream claim as it were, succeeds, some cases that its liability is zero, nothing at all. And so 65 million or more turns on the coverage question. Now, those list of issues are recorded in the list of generic issues that are to be determined at the 5-week trial in November 2025. And if I can just identify where you find that, it's in the supplemental bundle at tab 7. So this is the approved statement of agreed and assumed facts and the list of generic issues as between AmTrust and Sompo, which are to be determined in November. And at page 36, so tab 7, page 36, you have issues 2, 3 and 4, which are going to be determined. Scope of cover, would any of the contractual or tortious liabilities which AmTrust alleges that Pure and HF have to it fall within clause 1.1 of the PI policies? Issue 3, if and to the extent the answer to issue 2 above is yes, would any such liabilities be excluded from cover by clause 2.6b? And then issue 4, if and to the extent the answer to issue 2 above is yes, would any such policies be excluded from cover under the policies by clause 2.6c?
Yeah.
So those are the issues being tried. And let me take you to one clause of the policies before I take you on to the issue for the judge and his decision. The policies are back in the core bundle, and if we work from the one behind tab 19, that would be convenient. And the policies are all in comparable terms. This is the Pure policy for the 2021 policy year. And if I could ask you to turn to page 282, please. You'll see at the top of the page, the policy provides cover to the insured in the form of the minimum terms and conditions. Then, whereas a representative of the insured has made to the insurers a written proposal containing particulars and statements made to the best of the representative's knowledge and belief, which, together with any other information to supply to the insurers, shall be incorporated into this contract. That's what we've referred to as the incorporation clause. Not unusual, and it expressly incorporates those matters, proposal form, and any other information supplied to insurers into the policy of insurance.
But that was not what you're asking for. You're asking for correspondence over the previous 5 months, aren't you?
We are asking for a subset of that, my lady. It's quite right.
So just to...
Yes, and I'll just,
You'll come to that, I'm sure.
I'll come to that in a moment. Before we leave the policy, if I could just take you to 278, please. This is within the policy schedule, and you see the last entry on the first column is the heading information. The following information has been seen and agreed by insurers. Proposal form dated 4th of August, including list of directorships and note to PII, and then all sorts of other material as well. And we haven't seen any of that material. We haven't seen the proposal form. Sompo is refusing to give us a copy of that proposal form. Now, that was the context in which we sought disclosure and proposed issues for disclosure prior to the CMC that the judge heard. And one can see the issues for disclosure in the disclosure review document, which is back in the supplemental bundle, I'm afraid, at tab 8. And the relevant issues for disclosure that we're arguing about then and now are 1A and 1B, which are effectively in the same terms, albeit one relates to the insurance with Pure's insurance, one relates to HSS's insurance. And what we were seeking as a disclosure issue was what communications, if any, were there between Pure and Sompo at any time prior to the inception of the Pure 2021 policy regarding Pure's involvement in the scheme and or any agreements Pure had with AmTrust or CLE. So we weren't being greedy. We weren't asking for all the information that was provided. We were asking for a subset of that. We were asking for communications regarding Pure's involvement in the scheme and any agreements Pure had with AmTrust or CLE. So we're just asking for that material which will or may be relevant to the construction of the scope of cover afforded by the policies in respect of the scheme solicitor's liability to AmTrust under the TOBAs and under any duty of care.
Is the reference to CLE relevant?
Well, CLE was the agent of AmTrust, and that's concluded because it may be that some of the communications were between related to agreements between the scheme solicitors and CLE, like the TOBA which we've just seen. So it's included for completeness to make it clear that it can't be said, well, we don't have to disclose any communications about that TOBA because that TOBA on its face is with CLE, not with AmTrust. Does that make sense? So that was the subset of the communications that we're after. There's never been any suggestion that there'll be any difficulty in searching for these documents. No doubt Sompo has an electronic underwriting file for each of Pure and HSS, and it could easily search those files. And as we touched on earlier, it's because of the statutory transfer that we're in an unusual position here. We're not the insured who knows the information that was provided before the policy incepted. We are the statutory assignee of the insured, standing in the insured's shoes, and that's why it's particularly important that we're given this information to put the parties on a level footing. So that was my part one summary of the background.
Yep.
Part two, the issue for the judge and his decision. Well, what he had to decide was whether or not to include issues 1A and 1B as issues for disclosure, and you know that he did not. And it's against that decision that we appeal and say it's wrong. And I did want to take you to the reasons for his decision.
Yes.
Which are in the core bundle at tab 8. And we get, as it were, some supplemental explanation in his reasons for refusing permission to appeal as well.
Yeah.
His brief oral judgment is recorded behind tab 8. And we
So
could.
this was a Friday morning application.
Yes, we had a CMC. We covered quite a lot of ground, and
Sorry, I have other reasons for asking. Started at 10 o'clock. Not relevant to the, and he gives judgment at 10:56. Is that?
It probably started at 10:30.
Right.
And
No, sorry, nothing to do with this case. I'm just anecdotally, I'm interested in speed of.
I see. Yes. And just to be clear, as we went through issues, and he decided, he gave, as it were, mini judgments on each of those issues rather than saving everything up to the end. So the hearing went on after this, dealing with other issues. So
Yeah.
it's not as though all the business of the CMC was done in that initial period.
No.
And he set out in the first few pages the background, and the reasoning starts at paragraph 29 on page 89 of the bundle. And he says, so bearing in mind the party's submission, should disclosure be ordered in relation to disclosure issues 1A and B? Then he says, whatever I say is not intended to bear on the issues to determine at the issues trial or the party's ability to argue those issues. That was a bit odd, given that he went on to refuse to order disclosure in relation to those disclosure issues, because it does, of course, impact on our ability to argue at trial anything about the scope of the policy based on what was in the information provided, because we haven't got the information provided. So I've helpfully just been reminded that the start time was 9:30.
Right.
Not 10:30. So I'm an hour out. So that was odd. And he went on, I won't read paragraph 29 to you.
He also says immediately after that, I'm not engaging in any issue of construction.
As matters stand. Correct, my lady, that's quite right. And yet, effectively, what he went on to do was to construe the policy and form a view that this material that we wanted to see couldn't possibly be relevant. So having said he effectively wasn't doing anything, he then went on to do something. Paragraph 30, the mere fact that the insureds may refer to this transaction in terms of business does not, in my view, or is not likely to affect the construction of the policy. It may do. So he's, in the second sentence at least, acknowledging that this material may be relevant. And he then goes on, and if it became relevant later, it may be open to argument to either party to say it does. But for the purpose of ordering disclosure, I'm sceptical as to the relevance of this material for the purpose of assisting the court or indeed the parties when it comes to the issues trial. Now, I don't know how he envisaged it would work there, because if we went off to trial and I made submissions to the trial judge that this material was relevant, would the trial then judge break and say, right, I agree with you, Mr. Elton, let's have some disclosure on this, and that'll go on while the trial's going on? It just doesn't work. The disclosure has to be sorted out before the trial starts. And
yes, in fact, what you're saying is that his decision is precluding the possibility of it ever becoming relevant. He says it may become relevant and can be dealt with at trial, but it won't, because it won't be available.
No, and that's why he is determining the party's ability to argue these issues, because he's cut us off at the first base, as it were. Paragraph 31, he referred to the fact that I didn't just rely on the phrase professional business, but also the question of whether or not claims arise out of a connection with the conduct of any professional business. We may need to look briefly at the scope of the insurance clause.
But at the end of 30, he'd said, I struggle to see how the meaning of the phrase professional business could be influenced. And then he goes on to say, to wipe it out,
yes.
arise out of.
Yes.
Yeah.
We'll look at the insurance clause in a moment, and there are a number of ways in which this material may be relevant, and he's addressing two of them there. And he says, again, I struggle to see how the communications in question could influence the phrase arise out of in connection with the professional business, at least to a degree which would justify an order for disclosure. So he seems to have in mind that it might influence the construction of that phrase, but not sufficient to order disclosure. That all said, I do find it somewhat unsatisfactory that AmTrust, as a third-party assignee of rights under the policy, had not got access to relevant material. So there he's referring to it as relevant material, but acknowledging the obvious unfairness of us not having the material when Sompo does. And then at least for the purpose of understanding at least what was said. But even though I find that unsatisfactory, I'm not sure that it helps me to come to the conclusion that material will be relevant for purposes of construing this particular contract in this particular way. I mean, if he was applying the test of, well, will it be relevant? That's not the right test. The right test is it likely to be relevant? And what he's appears to fall into the trap of doing is sort of imagining that he was the trial judge, deciding on the limited material he had as to whether or not documents which he hadn't seen were relevant for the construction of those clauses.
Can I just pause there? You said the correct test is likely to be relevant. I think that's taken from the Parliament.
Yes, it is, my lady. Yes.
But actually, we're really construing the practice direction here.
We are.
In the context of the overriding objective, among other things.
Yes.
So one question might be whether by looking at the words likely to be relevant as used in Parliament, too much stress is being put on a particular interpretation of those words rather than looking at the practice direction and what it's designed to achieve.
Well, I entirely accept all that. And when I was, my section on where the judge went wrong is in two parts. One is dealing with the practice direction. The other is dealing with effectively the law on relevance of communications like this. And I entirely agree that he's rather elevated what was said, perhaps beyond where it should go to. But certainly, we would say that these documents are likely to be relevant. I mean, of course,
But yes,
it's not.
I'm making a slightly different point, which is it right to treat that as the definitive?
Yes. Well,
test?
I mean, he sort of. We'll see when he comes on to his reasons for refusing permission. He sort of treated that as a threshold issue, because he said, if I thought they were likely to be relevant, I would have accepted it was reasonable and proportionate to disclose them. Whereas the practice direction really starts with the question of, well, what's reasonable and proportionate? And a subset of that will be likelihood of relevance. But that's not the way he's approached it.
But anyway, it's notorious that the term likely is ambiguous.
Yes.
And even if it was the test, which I agree with my lady, I can't see anywhere where it is the test, there are degrees of likelihood. Yes. And degrees of relevance. So it's much more multifactorial than...
Yes, and it's never been suggested the test is more likely than not, for example, that sort of likely.
No. And anyway, you can't always tell whether it's likely to be relevant.
Until you've seen it.
Perhaps, yeah, I can see the argument in this kind of case it is more likely to be possible because you're dealing with to say that background material of this kind is less likely to be relevant because you're dealing with well-known standard clauses. But even so, it can't be black and white.
No. Particularly when the policy, and it's Sompo's own wording, contains the incorporation clause.
Yes, right.
So they've said, this material is incorporated into and forms part of our policy, but we're not going to let you see it. That's their position.
We have
so unattractive. And so, and he's elevated the test here from, even if it were a likely test, he's elevated it to will be relevant, it would seem. And so he says, with some reluctance, I have to admit, I refuse the disclosure sought on the basis of disclosure issues.
Pretty clear, the judge's gut was telling him, well, I'm not very happy about this. But his head was telling him, no, trust your head rather than your heart. Perhaps that's right. But,
we asked for permission to appeal. He said, well, give me some grounds of appeal, which we then sent to him in draft. And that's what led to his ruling on the application for permission to appeal, which is over the page at 91. And I think we can just skip on to paragraph 10 on page 94, which effectively explains how he reached where he got to and why he was refusing. I refused permission to appeal because I don't consider there's any real prospect of success on the issue, no other compelling reason, principally because this is a case management decision, and further, one, I could not discern the relevance of the documents described within disclosure issues 1A, 1B to the dispute. So in those circumstances, I was not satisfied the documents are likely to be relevant. That's the quote from Appellant.
Yeah.
Although I had regard to the overriding objective, there was no need to address expressly issues of reasonableness and proportionality once a decision was made that disclosure issues were not likely to be relevant to the fair resolution of the claim. So he's treating it as a sort of threshold issue rather than as one factor in a bag of issues to be considered. The avoidance of doubt, had I come to a different conclusion, I would have been satisfied that disclosure would have been reasonable and proportionate. So it's pretty remarkable that he's saying disclosure would have been reasonably proportionate, but because of the view that he had formed as to relevance, he was not ordering disclosure. It says the principles underlying the approach, the formulation of disclosure issues are reasonably settled. There's therefore no compelling reason for the Court of Appeal to consider this issue.
But this is this has become something that people do very often, and I can completely understand why. But we're concerned specifically with an appeal against the judgment and not the reasons
Yes.
for refusing permission to appeal. Although they do, as you say, shed some light on his thinking.
Yes, yes.
Has there been, I ought to know this, as my lady says, this is an issue that comes up quite often, where, particularly with extemporary judgments, where the reasons are amplified or restated in arguably slightly different terms or clearer terms when refusing permission to appeal. And we nearly always look at them because it makes sense to do so. But has there been any case in which, as it were, the analytical basis of doing that has been authoritatively considered?
If I may interject, because I've had to consider it very recently, I think there is, and people usually summarise it as you can refer by way of elucidating the judge's reasons. I can't remember them.
Well, of course, that's exactly what I was going to say. No, I wouldn't I'd very happily take that position.
There is some,
I mean, I think
there is a bit of case law on it, but my recollection is it doesn't spend a lot of time considering the juridical basis.
well, because technically the appeal is against the order rather than the judgment, which gives rise to the order.
Yes. But
The
one way or
order
another,
is-
it's nearly always going to be relevant if the judge says something useful. For example, we may decide that the reasons given in the original judgment were inadequate, and therefore, if we were very purist, the appeal must be allowed. But with the help of the reasons given second time round, we make the same decision. So there's all sorts of routes by which it is relevant.
Yes.
I just wondered whether anybody has ever sat down and written a judgment spelling out the ways in which it may be relevant. If they haven't, I'm not sure to do it this time. But
I can't point you to the decision if it has been done. So that's part two, the issue for the judge and what the judge decided. And then part three is where the judge went wrong. And as I say, this falls into two halves. And it may be that some of this I don't need to go into detail on. But the first part is to look at the practice direction, and the second part is to look at the textbooks on insurance that deal with the relevance of pre-contractual material, particularly that which is incorporated into policies, much of which is just bread and butter stuff, quite frankly. But the judge didn't see it that way, which is why sometimes have to.
up to you, but you do set them out very clearly in your skeleton argument. But I think we would like to look at the practice direction.
Yes, of course. Well, that's in the authorities bundle at tab 32. And it falls into various sections dealing with duties in relation to disclosure, preservation of documents, initial disclosure. The relevant section for our purposes are sections 6 and 7, extended disclosure, and identifying the issues for disclosure and models. And section 6 is on page 790 of the authorities bundle. And the sort of starting point is 6.3, really. The court will only make an order for extended disclosure that's search-based, i.e. model C, D and E, where it's persuaded that it's appropriate to do so in order fairly to resolve one or more of the issues for disclosure. In all cases, having an order for extended disclosure must be reasonable proportionate, having regard to the overriding objective, including the following factors. And just to pause there, the overriding objective, of course, includes putting the parties on an equal footing, and we referred in our skeleton to...
We didn't actually have it in the bundle, do we?
No,
I think it's this.
No.
as you say, but the bits of it you're relying on are putting parties on equal footing.
Yes, and we've referred to the decision where it was emphasised.
Was that recent decision of Lord
Alan
Justice
Shell case.
Stuart Smith, Lord Justice Stuart Smith?
Yes, that's the one.
Yeah.
Not Alan Shell.
Alan May.
Sorry, yes, it is that one. One of the most important tools for achieving justice and ensuring the parties are on equal footing is the process of disclosure. And I just happen to note that one of the members of the court was Lord Justice Males in that case, who of course gave permission to appeal in this case and identified as an issue the importance of the parties being on an equal footing.
Can I just get one thing off my chest? So I happen to remember a bit as being Alame, reading with an A. I find it tiresome that the authorities in the bundle were in alphabetical order.
Not chronological.
They I think a recently published Court of Appeal guidance has made that clear, but just from those behind,
Yes.
didn't matter much in this case, but
No,
chronological is the right way.
Thank you.
Okay.
So 6.4.
6.4, so sorry, that was spinning off from the overriding objective, and the particular element of the overriding objective is putting the parties on equal footing.
Correct.
Any other elements in particular?
No. But then you have a breakdown of factors in 6.4, and when one looks at those, all of those point in favour of disclosure here. The nature and complexity of the issues in the proceedings, the importance of the case, including any non-monetary relief, well, it's 65 millions, the likelihood of documents existing that will have probative value in supporting or undermining a party's claim or defence. Of course, there's no doubt that these documents exist. You've seen one of them listed there in the information on the policy. And Sompo's never said we don't want to disclose these because they don't exist. It doesn't want to disclose them. Well, you'll be told why it doesn't want to disclose them. The number of documents involved.
Well, I think probably, we don't need to do an elaborate construction of this, but reading it as a whole, the concept of likelihood also applies to whether they're probative value. It's not just do these documents exist. You could expand it a bit, saying the likelihood of documents existed and the likelihood which are likely to.
Yes, they must be documents that will have probative value.
Yes, so the concept of likelihood affects the whole.
Yes.
But the likelihood, putting it that way, is not a 50% plus one binary test. It's a spectrum. How likely is it?
But it's also one of a number of factors to take.
One of 7 factors.
Yes, absolutely.
Rather than the.
And even that is an inclusive list, including the following factors. So that is one of 7 factors to be taken into account. The number of documents involved, well, you've seen that we've asked for a subset of what we know is out there. Ease and expense of searching for and retrieval any particular document. It's never been suggested there would be any difficulty in searching for or retrieving these documents.
Yeah, I understand you're banging the nails, but really, unless I'm doing an injustice to Mr. Hoff, he's not taking a point on any of these except for relevance.
Yes.
Yeah.
Yes. But that said, it's it's important to bang home the nails, because relevance. The danger otherwise is that you elevate relevance to the sole factor rather than one of 7 inclusive factors. Financial position of each party. Well, of course, we've got two insurance companies here, and the need to ensure the case is dealt with expeditiously, fairly, and at a proportionate cost. And that fairness issue again goes back to the fact of need to put parties on an equal footing, and you can't have 2 parties arguing over the meaning of a contract when only one of them knows all the terms of the contract. It's just not fair. So that's 6.4. Then the specific, it may help to take you to 7.6. Section 7 deals with identifying the issues for disclosure and models for disclosure. And paragraph 7.6 is the guidance that we have about what the issues for disclosure should be. It did occur to me as I was walking over here that it's ironic that this process was made to make disclosure so much easier, and here we are in the Court of Appeal arguing about whether or not an issue for disclosure should have been included in the DRD or not. But we are where we are. 7.6 says the list of issues for disclosure should be as short and concise as possible. Issues for disclosure means, for the purpose of disclosure, only those key issues in dispute which the parties consider will need to be determined by the court, with some reference to contemporaneous documents, in order for there to be a fair resolution of the proceedings.
Your emphasis, of course, is on fair resolution.
Yes, yes. And nothing in there about any threshold test of relevance. And you've seen that the generic issues 2, 3, 4 are issues to be determined at the trial. They will need to be determined by reference to contemporaneous documents, naming the policies, including any information such as the proposal and any other documents incorporated into the policies. So that's why these were appropriate issues for disclosure. Would it help to take you to McParland to see how that fits in?
I think we should look at McParland, yes.
That's in the authorities bundle at bundle 14. I have a slight cold shiver when I see this case, because it was two counsel who I think just turned up to have a knockabout disclosure hearing. And all of a sudden the Chancellor is in front of them and gives chapter and verse on what disclosure, how the disclosure regime should work.
Yes, that does sometimes happen.
Rather them than me. It was a disclosure guidance hearing.
Sorry, my bundle has come to bits.
Tab 14.
Sorry, you just wait while I reassemble my bundle. Okay. Yes.
And so this to be technically accurate, his judgment does not relate to Practice Direction 57 AD. It relates to the
Pilot predecessor.
yes PD 51U.
But there's no substantive difference,
No,
is there?
I'm not suggesting there's a distinction to be drawn for that reason, but just to get the chronology of the case and the legislation in order.
Yeah.
It was a disclosure guidance hearing, and the paragraph 44, he picks up a section of his judgment where he's dealing with the identification of issues for disclosure, because he was, if I can summarise, pretty unimpressed with the way the issues for disclosure had been prepared in that case, and he gave some guidance as to how issues for disclosure should be prepared. So it's the starting point for the identification.
Can I just get this clear in my head? That isn't really a problem area here, is it? It's the issue for disclosure is issues for disclosure are the construction of the scope of the policy and the two exclusions. And where we have a problem, where the judge thought there was a problem, is whether the documentation sought was relevant to those issues. Nobody's suggesting those were not issues for disclosure.
Well, I think what would be said is actually, though the first thing you've identified are issues for determination by the trial judge, legal issues, the proper construction of the policy. Issues for disclosure are not the legal issues in the case.
Now, I see that, and you're right to make that point, but this isn't a classic case where there are lots of sub-issues and some of them don't require documentation. This is the core issue, and the issue is whether, the question is whether, in order to determine that core issue, it's certainly key issue, further documents are required.
Yes, yes.
And really, under which label you put it, perhaps isn't very important.
But the outcome of the outcome of the question of is it fair to order disclosure is, do you include this as an issue for disclosure?
Yes,
or
I
do
see.
you
No,
not?
no, you're right to correct
There
me.
is a point that what Chancellor was doing in Parliament was making it clear that not every issue in the trial may have contemporaneous relevant documents.
Absolutely,
That was
absolutely.
the key point he was making.
Yes.
Yeah.
I think.
And I think he was trying to draw. I mean, things can get a bit confusing because you, of course, have the list of issues that you routinely prepare for a CMC for case management purposes, but those are the list of issues in the case that need to be determined at trial. But the point he was making here, principally, was well, that is different to the list of issues for disclosure, because, as my lady says, a lot of issues, some issues will not need any disclosure at all. And that's why he says, paragraph 46 is deals most precisely what we were
Yeah.
just discussing.
Yeah,
It can be seen, therefore, that issues for disclosure are very different from issues for trial. Issues for disclosure, issues to which undisclosed documentation in the hands of one or more parties is likely to be relevant and important for the fair resolution of the claim.
I think that's my point, because those are the words relied on, but they're being made in the context of making that point.
Distinction, yes.
Distinction.
Yes, and what the judge has done is rather to take those words and elevate them to a sort of threshold test, and moreover to really convert them into not just likely but more likely than not, or in fact whether or not a final determination of whether or not they will be relevant. All of which is a task that should be left to the trial judge, not dealt with at a CMC, when you might shut out disclosure of documents that the trial judge ultimately says, well, actually, I do want to see those. And then you get into a total muddle because disclosure hasn't taken place. So that's probably all I wanted to take you to in Parliament. And the judge's error was not to take a whole basket of factors into account if they're not deciding to include these as issues for disclosure, only focusing on the issue of relevance and dealing with the issue of relevance as either more likely than not, or will be relevant, or such a hurdle as he mentioned in his judgment. Whereas he should have done what the practice direction said and asked, well, is disclosure appropriate for the fair resolution of the proceedings? Which he just about acknowledged it was necessary, because he said, it does seem a bit unfair that someone's bringing a claim on a policy and they can't see all the terms of the policy or the underlying documents. And the parties aren't on an equal footing. So that was the sort of first part of my third section of my submissions,
Yes.
the practice direction. Unless there's anything else you want me to deal with in relation to that, I was going to go on to part 3B, as it were, the issue of relevance. And
Yes.
here some of these principles are so well known that I'm slightly reluctant to take the court to them. But
Well, it's up to you. I think, as you say, if I remember, they're all set out very clearly in your skeleton arguments. But I think what Mr. Hoff would say is, well, fine, but they're at a high level of generality. Let's just look at what the cases are.
I was going to take you. I've got three on my list, really, or four. FCA and Arch, the Supreme Court's recent test case.
Yeah.
Paragraph 47.
Yeah. Well, you set out the key passage at paragraph 30.
Correct. And then Colin Vaux, the textbook on the importance of the factual matrix and so on, because that's specifically in the insurance context.
Yes.
And then McGillivray.
Yes. So it's 33 and 34 in your.
Yeah.
I mean, it's up to you. I'm not stopping you, but because you say you're yourself reluctant.
Well, I've got to make best use of my time.
But what is being said against you, I think, is, well, that's all very well and it's true as a matter of principle, but in the facts of this case, how can the kinds of thing that one might reasonably expect to be in the incorporated documentation actually bear on the meaning of the key phrases?
Yes. Can that's very helpful. And so what I'll do is I'll go to the terms of the
My ladies
policy.
think I'm taking this too fast. No.
Before I do that, can I just take you to one case?
Yes.
And it's by way of illustration, really, but it's a useful illustration. It's the quantum processing case, which is the Court of Appeal's decision at tab 16. And this is the one we refer to in our skeleton. It was a claim on a travel policy, and the insured had been injured while cave diving. And the claim was made under the policy, in fact not by him, but by an assignee. He assigned the claim to someone who had paid for the medical expenses. And the trial judge said, well, there's no cover because the policy excludes an exclusion for hazardous activity, and cave diving is a hazardous activity. And there was an appeal against that, and the Court of Appeal said, when one looks at the information that was provided to the insurer before the policy incepted, the insurer has to pay up. And therefore the decision was reversed, and it was held the insurer was on cover and had to pay. And so it's a good illustration of where, if the claimant had not been able to point to that pre-contractual exchange, it would have lost. But as it was, it won. And I just can take you to two passages to make that good. The first is at paragraph 12 on page 427. Where Lord Justice Waller quotes from the relevant exclusion clause. This insurance is available for holiday or business travel, but excludes permanent overseas residency, permanent overseas employment, work of a predominantly manual nature, or any hazardous activity. That was the key phrase. And then he picks it up at paragraph 14. What happened on this occasion was that Callan Fraser, that was the insured, disclosed, in accordance with the advice under the Code of Practice, that he was going to engage in diving on his holiday in Mexico, and he clearly followed the advice to disclose what can only be described as hazardous activity. It seems to me, once a disclosure has been made of hazardous activity, and once that hazardous activity has been accepted by the insurers as covered by the policy, either because they've said, well, we'll cost you a little bit more and charge an extra premium, or simply accept it as covered, then the policy only makes sense if the general conditions are read as if that disclosed hazardous activity had been written into the policy as covered. So those general conditions, as it seems to me, should now be read in the context of this case as, and he's quoting from paragraph 12, this insurance is available for holiday or business travel, but excludes, leaving out unimportant words, or any hazardous activity, save for scuba diving. So it's just an example of how the background material and the information that's presented to an insurer before a risk is bound can make all the difference between there being cover or no cover. So let me turn then to the terms of the policy. We can go back to the policy in the core bundle at tab 19, please. If we start on page 282, please. I've already referred to the incorporation clause at the top of 282 and emphasise again that this is wording that Sompo has included in its policy, and it's so unfair to say, having said in its policy that the information supplied shall be incorporated in this contract, to then say to someone who wants to make a claim on that contract, I'm not going to show you the information that was supplied. It means that we are not being seen all the relevant terms of the policy. Now, Sompo places much reliance.
Also, it could be argued that there's no way in which the judge can construe the contract unless he's got all the parts of it.
My lady, absolutely. I mean, you know, there are so many relevant principles of construction. One, of course, is that you have to construe a contract by looking at the whole of its terms. And how can you do that with only some of its terms?
Sorry to have interrupted you.
Sompo places much reliance on the authorities which state that when a court's construing the terms of a standard form contract, the relevant background is of limited relevance. I'll just make 2 points about that at this stage. Firstly, because of this incorporation clause, that necessarily means that each policy is not a standard form contract because it each incorporates different information. So once the policies are concluded, incorporating the information that's provided, each policy is different. They may have all been based, as it were, on the matrix of the standard wording, but as finally concluded, since they include the information provided, they're all different. And secondly, those cases, when one looks at them, they don't say the factual background is irrelevant. They just say the factual background is of less relevance than in cases where you're construing non-standard forms of contracts. We accept, of course, this isn't a basis clause, but we've never said it is a basis clause. It doesn't need to be a basis clause to be effective to incorporate the proposal and other information into the document, into the policy. So that's the first of 4 clauses to look at. The second is the insuring clause, the primary insuring clause at 1.1. And you'll recollect what we're going to be arguing about at trial is whether or not the scheme solicitors, if we show that they were in breach of the terms of those TOBAs or acted negligently, whether their liability to AmTrust, because they didn't assess the claims properly, for example, is one for which there is cover under this policy. And it contains the usual wording about indemnifying the insured from claims and circumstances, and then just skipping ahead to the last 2 lines, provided that such claims or circumstances arise out of and or in connection with the conduct of any professional business carried on by or on behalf of the insured. And professional business, I'll just give you your note, the reference to that is at page 301, the definition of that, and it's the provision of services as a solicitor. But what's significant about this proviso is that it is wider than the minimum terms. It's common ground that this is wider than the minimum terms because the proviso is that the claims arise out of and or in connection with the conduct of services of a solicitor.
What's the minimum term?
Minimum terms is that it is arises from private legal practice. So the widening words are and or in connection with, which the minimum terms don't require to be in there, but Sompo has chosen to include in its wording. And we've included the reference to Standard Life and ACE, the decision in which Mr. Justice Eder observed that the words in connection with are extremely wide words. And the fact that you have those extra words mean that this clause is different to those that were considered in Doorway Capital and the Sutherland case. So those cases were not dealing with this insuring clause.
That was Doorway Capital and...
Doorway Capital is the first one, which is at Authorities 5, and Sutherland, which is Authorities 19.
Thank you.
And the scheme solicitors in this case, of course, provided their services in 2 different ways. One, they were acting for the consumers, progressing the underlying cavity wall insulation claim, or mortgage mis-selling claim, including arranging ATE policies, advising on the merits of the claims, issuing proceedings in those cases that got that far. There's no doubt that was providing the provision of services as a solicitor, that's just ordinary solicitor work. And then they were also providing services to AmTrust under the TOBA, as we have seen. And so the argument for the trial judge will be whether or not there's no cover because of the application of this proviso, because our claim does not arise out of and or in connection with the conduct of any professional business. Now, it may, we refer to the fact in the amended, in the Part 20 claim, that Pure entered 14,000 claims into this scheme. HSS entered 2,800. Our understanding is that this scheme was a very substantial part of their work. That many claims.
Whose work?
Sorry,
Of these two firms.
Yes. And when the scheme collapsed, they collapsed.
Yeah.
And we anticipate that Sompo was made aware of the scheme and the involvement in the scheme. And we're standing in the here we have to imagine that it's the scheme solicitors seeking an indemnity for their liability to AmTrust. And imagine Sompo had said to them, well, okay, you've been found liable for breach of that TOBA, you've been found liable in negligence and the way you conducted as part of that scheme, but we're not going to insure you because that's not conduct that arises out of or in connection with the conduct of professional business. You would expect the insurers to say, well, what do you mean? We told you about our involvement in those schemes. You can't now say that you're not going to cover us when we told you about them. They may be able to go further and say, we actually discussed those schemes. We gave you provisions of the TOBAs. You charge an extra premium. We don't know any of those facts because they're not, we don't have the documents or the information. But just considering the question of, well, might this material be likely to be relevant? Might it be relevant and have probative value such that it's reasonably proportionate to include these issues for disclosure? The answer must be yes. And I was thinking of ways to test this. If you, when you're in practice, you were provided with this policy and asked to give some advice on its cover, and you saw in the list of information provided, item 1, proposal form, and you saw that that proposal form was incorporated into the policy, might you say, could I see that proposal form, please? Because that's going to inform my assessment of the cover. If you're the trial judge and you're arguing about this, might you think that the insurer's awareness of the insurer's involvement in this scheme and the TOBAs and the obligations assumed by the firms under the TOBAs might be relevant to the scope of cover and whether or not the insurer could get out of cover, then my submission, you'd say, yes, I would like to see those documents.
Just so I can get this clear in my head, clearly it gives you an important, I don't mean this anyway rude, the debating point that the all these materials, these documents are described as incorporated in the policy. Never really had to think about what incorporated in the policy means. If they don't state terms, what does it mean? The underlying substantive point is that they are part of the factual matrix known to the parties.
Yes. I mean, I would be making in a way that the same argument,
In a sense,
even if
the
there
point
wasn't
would
the incorporation.
exactly,
Yeah.
exactly.
Because it's all part of the factual matrix.
What does it mean to say you incorporate a whole lot of documents in the policy
Well,
if they don't purport to state any obligations?
Well, it's difficult to answer that question without seeing the documents. But if one just takes, for example, the quantum processing example that I just gave, there the Court of Appeal, albeit there wasn't an incorporation clause, it just said by reference to the factual background, that disclosure has the effect of amending the terms of a condition.
Well, I know. Okay, I see why you like the quantum case, but I'm just, for my own clarity of thinking, trying to see what the real essence of your point is, and I think you're tacitly accepting that your point would essentially be the same, even if there wasn't an incorporation clause.
Well, it makes
It makes it easier for
Yes.
you. But actually, I'm not sure why it makes it easier for you. It's probatively clear that everybody had these in mind. But I still don't quite understand what, when you incorporate a proposal, what you're actually doing.
yes. Well,
Some of them are. I mean,
in a
some of
way-
these documents are not. I mean, the proposal is the most obvious and clear-cut one. It's the closest to the contract. The rest are a lot of emails and
well, we
you
just
don't know
don't.
what they say.
Well, that's why what we've asked for is information about these
No,
agreements.
well, I see that. I see that, but I suspect you see more insurance policies than I do. But I'm familiar with the concept of having some boilerplate language incorporating lots of documents. What do insurers normally mean by saying that?
I'm not sure that
The answer is they don't really think about it.
probably.
Yes.
Probably.
Yes. Okay. Well, I don't want to spend any more time on this, but I just wanted to flag up
I mean,
where the real essence of your point is.
well, it's probally my fault for having skipped over those authorities.
But it's
where I
my fault
pointed
for
to
having
the fact-
encouraged you to do so.
the and that to a certain extent overlaps with the factual matrix point, but it's just so clear that to put parties on an equal footing when they're arguing over the terms of a contract, they've got to both have the terms of the contract.
Yeah, well, I get that.
Yeah. And the factual background is, the cases we refer to make clear what they are. What is the factual background? The factual background is the material that would have been available to the parties when the contract,
exactly.
which would include this. And then how would that fit into the argument about the scope of cover? Well, the trial judge might, and I don't need to say more than might, say that, well, if you, a Sompo, are saying there's no cover here because these claims don't arise out of and or in connection with the conduct of any professional business, I'm entitled to consider whether or not that proviso is applicable by considering what was known to insured and insurer when the policy was bound, including the insured's role in this scheme, particularly if it was a substantial part of his business, particularly if copies of the details of the TOBAs and the duties owed to AmTrust and so on were referred to. That will inform the question of whether or not, in fact, Sompo can successfully decline cover by saying, well, this liability does not arise out or in connection with the conduct of any professional business.
It's basic construction and interpretation of contracts, and whether you call it incorporation or whether you call it the relevant factual matrix, it affects what the words in the contract mean.
Yes. So that's the second of the four clauses. The other two which we haven't looked at yet are the exclusions, which are on page 285. These are the two exclusions that Sompo relies on, at 2.6b and 2.6c. Firstly, there's no liability for a claim arising out of or in any connection with any legal liability assumed or accepted by the insured under any contract of agreement for the supply to or used by the insured or goods or services. And that's a classic case of, hiring a photocopier. There's no liability for that, for example. A debt claim. We say that's simply inapplicable because by those TOBAs, the scheme solicitors weren't assuming or accepting any legal liability, and the services were being provided by the insured to AmTrust, not by AmTrust to the insured. So that's why there's an argument about the scope of that exclusion. And if I can just, in this context, refer you very briefly to the impact funding case. The last case I want to just take you to, just because it's a fairly recent Supreme Court decision in tab 10 of the authorities bundle. And if I could just take you in the speech of Lord Hodge, who gave the majority decision, firstly at paragraph 5, 320. In determining the appeal, the court has first to construe the relevant terms of the policy against its factual matrix, and secondly to construe the relevant terms of the disbursements funding master agreement between Impact and Barrington, once again against this factual matrix. And then paragraph 7, the extent of AIG's liability is a matter of contract and is ascertained by reading together the statement of cover and exclusions in the policy. An exclusion clause must be read in the context of the contract of insurance as a whole. It must be construed in a manner which is consistent with and not repugnant to the purpose of the insurance contract. And then lastly, I could take you to what Lord Toulson said at paragraph 35 on page 327. The fact that the provision in a contract is expressed as exception does not necessarily mean that it should be approached with a predisposition to construe it narrowly. Like any other provision in a contract, words of exception or exemption must be read in the context of the contract as a whole and with due regard for its purpose. As a matter of general principle, it's well established that if one party, otherwise liable, wishes to exclude or limit his liability to the other party, he must do so in clear words. The contract should be given the meaning to convey to a reasonable person having all the background knowledge which is reasonably available to the person or class of persons to whom the document is addressed. So one needs to see the background factual matrix in play when these policies were banned in order to consider the proper scope of these exclusions on which Sompo relies, to see if Sompo is entitled to say, well, all that liability to AmTrust, we haven't got cover for that because it's caught by these exclusions. Or would the scheme solicitors be able to say, well, that's repugnant to the whole purpose of this policy. A big part of our job was involvement in this scheme. You knew about our obligations we'd assumed to AmTrust. You're happy with those. How can you possibly exclude cover? And the same point applies in relation to exclusion clause 2.6c. We've got the same arguments about whether that applies, and it'll be informed by the factual background. So that comes to the end of part 3b, why the relevant documents at least might be relevant, and I'm afraid the judge just got it wrong, and his decision should be reversed, and issues 1a and 1b should be included as issues for disclosure. If there's anything else, that's, I think, time for me to yield.
Can I just ask you, it said, probably against you, that it was just a case management decision that we shouldn't interfere with. How do you package it?
I can't dispute that it was a case management decision because the rules actually identify what is a case management decision, and they include in the list of those decisions decisions relating to disclosure. But 2 points I would make. One, just because a case decision is a case management decision doesn't mean it can't be reversed. If the judge has taken into account factors that he shouldn't have taken into account, or not taken into account factors that he should have taken into account, or made an error of law. And secondly, this wasn't the judge exercising any discretion. You've seen that in the part. That's the importance of looking at the reasons for his refusing permission. He didn't do a weighing up exercise of, well, let me consider this factor and this factor to see if it was reasonable and proportionate toward a disclosure. He based his decision on one thing, relevance, and that's a legal question. So it was a case management decision, but it was a wrong one because it was based on a wrong view of the law, and he wasn't exercising any discretion.
And can I also take you back, Mr. Elkington, to the practice direction and that subparagraph with the 1 to 7
Yes.
factors? What, just in a nutshell, would you say is the right approach?
The right approach for the judge is to have regard to all of those factors, and it's an inclusive list, but the judge is required to have regard to the overriding objective, including the following factors. And obviously I'm not going to say relevance is irrelevant. You ignore relevance because then you might say, well, all sorts of things which aren't relevant should be included. But the test, a judge carrying out this exercise should not be doing is pretending they're the trial judge and forming a final view on relevance. They shouldn't be asking whether documents are more likely than not to be relevant. They should just be considering, as this says, the likelihood of documents existing that will have probative value. And I don't know that one needs a greater gloss on that phrase there. That's dealing with the question of relevance, the likelihood of documents existing that will have probative value.
Thank you.
Thank you very much, Mr. Huffington. Yes, Mr. Hall. I am pronouncing you correctly, aren't I?
Yes. My lord, my ladies, our case is simple. The deputy judge at the CMC was fully justified in refusing to order the inclusion of the disputed issues for disclosure in the of the generic issues trial. He had to take a view on the likelihood of the documents in the categories sought being relevant for the resolution of the generic issues. Now, before him, AmTrust's central argument was that pre-contractual communications were likely to, may well, influence the meaning of the insuring clause in each of the standard form solicitors' professional indemnity policies. And specifically, AmTrust argued that they would influence the meaning of the expression, the provision of services as a solicitor. We say the deputy judge was justified in rejecting that argument. Since
Is that, are you making a point that emphasis wasn't put on the phrase in connection with?
Well, we say that the deputy judge was right to say that the meaning of the connecting words was not going to be changed by pre-contractual communications either. Since the CMC, AmTrust has added the argument that pre-contractual communications were likely to, could realistically influence the meaning of an exclusion clause, the trading debts and liabilities exclusion. We say that argument fares no better. This is, as my lord and ladies won't be surprised to hear, not the first time that a judge at a CMC hears one party seeking disclosure by way of introducing disclosure issues to bring in a morass of factual matrix material. And the judge, a busy judge in a CMC, has to take a view on whether the particular term that is to be construed under the legal issue for trial justifies the disclosure issue and thus opens up a range of disclosure. Now, there are some clauses in this insurance policy nobody could sensibly say brought in factual matrix material. We have exclusions for personal injury or property damage. It's difficult to see how those could be influenced by factual matrix material, with or without the basis clause or incorporation clause or preamble. And we take my lord's point about the significance of that, and I'll come back to that later. The question for the judge at the CMC was whether the clauses relied upon by AmTrust were of a kind to justify ordering the disclosure being sought. And we say our position is that as a matter of principle, the expression, the provision of services as a solicitor, has what I think was discussed in the judge's ruling as a stable and autonomous meaning. It is an expression which is the cornerstone of solicitors' PI insurance. It has been in the minimum terms and conditions for donkey's years. It has been addressed in multiple cases, and in not one of those cases has it been suggested that the meaning of that expression might change depending on communications between the insured and insurer, or between placing and producing broker in the period running up to inception. So that's what we say by way of introduction. In terms of structure of submissions, what I propose to do is address 6 matters, bearing in mind what we've already covered and the urge for economy. First of all, a few relevant points of background to the dispute, the litigation, and the policies. Secondly, the disputed disclosure issues and the test the deputy judge had to apply. Thirdly, AmTrust's argument based on generic issue 2, the construction of the insuring clause. Fourthly, AmTrust's argument based on the preamble to each policy wording. Fifthly, AmTrust's argument based on generic issues 3 and 4, construction of the trading debts exclusion. And then
Sorry, construction of what?
the trading debts and liabilities exclusion.
Yep.
And then sixthly, a brief response to each of the grounds of appeal. Now, by way of background, my lord and my ladies have heard about the background of the scheme and the litigation. I don't propose to cover that ground again, but just in response to what my learned friend said in relation to the totals, there are, of course, substantial disputes about the meanings of the terms to which he took my lord and my ladies, and there were a number of terms to which he didn't take you, on which we place reliance. I don't propose to go through an exposition of those contracts, because it's not for this court today to decide upon what duties the tablers in fact impose. That's for the trial judge. But I make that point just as a caution, not to suggest that these issues of whether vetting obligations were owed are straightforward or have only one answer. But it is worth bearing in mind that AmTrust alleges that the scheme solicitors owed duties of a kind which were very different from the obligations ordinarily owed by solicitors to their clients. So, for example, AmTrust alleges that each of Pure and HSS owed contractual obligations to ensure that the clients complied with the terms of their ATE legal expenses insurance policies by giving specific notifications at specific times and so on. Now, that isn't an obligation which would necessarily be owed by a solicitor to the client. There might be, as a matter of reasonable care, an obligation to give your client guidance on some of those matters, but not to the extent which is alleged.
Why are you making all these points? Just as you say, it's not for us to construe what is meant by, or which obligations are matters of professional business. So, how is it helpful? I'm
characterising the obligations to set up the exercise which will be undertaken at the issues trial, which is critical to the question of what disclosure is required for it. And the exercise will be for the trial judge to construe the relevant clauses of the insurance policies, and then to consider whether each form of liability alleged falls within the rubric provision of services as a solicitor. And our argument will be, in relation to a series of these obligations, that they are not services characteristic of a solicitor, bearing in mind case law such as impact funding. So that's why I refer to those, the obligations which are alleged. And likewise, there is an allegation that each of the scheme solicitors owed obligations to vet the claims before they even took the clients on. And there, again, there will be a question whether that vetting obligation fell within the classic rubric, the provision of services as a solicitor. And that's the nature of the dispute. At the first CMC, Mr. Justice Foxton decided that this litigation should be managed in stages, with the first stage being a generic issues trial, which is the trial to be heard in November. Most of the issues, which the parties subsequently agreed, are issues of law and construction to be determined without disclosure or witness evidence. As a result, in this substantial trial, as between Novitas and AmTrust, there is no extended disclosure at all, despite the fact that there are a whole series of issues of construction of standard form agreements of various kinds. AmTrust, in fact, sought at the first CMC to obtain a first trial with extensive disclosure and witness evidence, but the court preferred to go down the path of generic issues of law. At the second CMC, AmTrust made a further bid for disclosure of lending files from Novitas to provide a context for the various contracts. It failed for the same reason. At the second CMC, a deputy judge gave directions for the production of disclosure review document, but made clear that this would be strictly limited to disclosure relevant to the issues trial, and he stressed when doing so that there may be very little disclosure. So, in taking the line we ultimately took at CMC number 3, we have not taken a position which is out of line with the course of this litigation. And the decision needs to be taken in the context of a case management hearing for the purposes of the generic issues trial, in which most of the issues will be of law and construction. May I then go back to the PI policies, just to pick up a few points which may not have been identified so far. And I'll work from the pure policy which you Lordship and your Ladyship have been looking at so far, which is core bundle divided 19. At page 277, you see the risk details schedule with the expected entries included for insured.
So sorry, where I'm on 277?
277, yes.
Yeah,
So
which element?
So we have the expected entries for things like the insured and so on.
Sorry, the expected.
We have the entries one might expect.
Oh, I'm so sorry. I misunderstood. I thought that. Yeah. Okay. Yeah.
Identifying the period of insurance and the insured and so on, and then interest. England and Wales solicitors, as more fully declared in the contract word. And so, by contrast with some forms of professional indemnity insurance, one doesn't have a description of the insured's particular business in the risk details. There is a standard interest and business description which we find in the contract wording. And then page 282, your Lordships and Lordship and your Ladyships have seen the insuring clause with the proviso that the claim or circumstances must arise out of and or in connection with the conduct of any professional business carried on by or on behalf of the insured. And professional business is defined at page 301, paragraph 6.27, as the provision of services as a solicitor. The solicitor is defined at the bottom of page 302 as a person admitted to the Law Society role. And as we'll say, the concept of provision of services as a solicitor is the foundation of solicitors' PI insurance. It's been there in the minimum terms for a long time. I'll come to the minimum terms a little later. It's been considered in a number of cases. You've also been taken already to the exclusion clause relied upon, 2.6, trading debts and liabilities, which is at page 285. And just to explode one fallacy which was put before you, 2.6b, the first limb on which we rely, is not, as the courts have held, is not limited to liabilities arising from hire of photocopiers and the like. And it was this limb which in impact funding and in the other cases concerned with funding arrangements led a series of courts to say that liabilities assumed by, or obligations assumed by solicitors under agreements with litigation funding partners were excluded from cover. So those were the that's the insuring clause and the two exclusion clauses referred to. And those gave rise to the three generic issues that you have been shown, which are straight issues of construction about whether the contractual and/or tortious liabilities which AmTrust alleges that Pure and HSS have to it fall within first of all the insuring clause and then each of the exclusions. So those issues have been crafted with care to say, look at the liabilities which have been alleged and ask whether they fall within these clauses. And so, as I say, the exercise for the judge at the generic issues trial will be to look at what has been pleaded and then to say, does it fall within each of those clauses, the insuring clause or either the exclusion clause lens. So, for example, AmTrust pleads that each firm owed and breached a duty to vet potential clients' cases before taking them on. The judge will consider the meaning of the expression provision of services as a solicitor and decide if a liability for breach of a preliminary claims vetting duty owed to an ATE insurer arises out of and or in connection with the firm's provision of services as a solicitor. And likewise with the two generic issues concerned with the exclusion. So that's what we say by way of background matters. Let me then turn to the disputed disclosure issues and the tests to be applied. Now, AmTrust and Sompo were able to agree on most of the issues for disclosure, models for disclosure, and Model C inquiries for the generic issues trial. There remained a few points to be disputed at the CMC last December, and this was one of them. Now, the two disputed issues for disclosure at the heart of the appeal you have been shown, and they are expressed as what communications, if any, there were between Pure and Sompo at any time before inception of the policy regarding the scheme solicitor's involvement in the scheme. Now, those were identified by AmTrust in the DRD as just being relevant to generic issue 2. That's for your note of the supplementary bundle, divided 8, page 42. In connection with those issues, AmTrust was proposing disclosure searches for 5 months before inception of each of the 3 policies in issue. Now, we don't say that the exercise of search and disclosure would have been vast and infeasible, but it wouldn't have been a small exercise. It would have been more extensive than a number of the disclosure searches which have been sought and refused already in these proceedings, and it would not just be a question of opening or transferring a single electronic file. Let me then turn to the test to be applied, and I hope there isn't a great deal in dispute on this topic. You have been shown the practice direction, but in my submission it's worth going back to it. It's at Authorities 32. And the approach to disclosure in business and property courts, as I hope my ladies will be aware, at the CMC, each party says we will or won't want extended disclosure, and then proposes issues for disclosure, and against each issue, a model, A to E, ranging from no reliance right through to Peruvian guano, and for Model C, inquiries to be answered. Now, in our submission, the first stage in identifying an extended disclosure issue is to identify a factual issue which is likely to give rise to disclosure of documents, contemporaneous documents. And
why do you say a factual issue rather than a legal issue?
Well, as we'll see from the MacDonald case, what one does ordinarily is to look at the legal issues and then identify issues which are likely to throw up contemporaneous documents. So, for example, one might have a question whether X was the agent of Y. The factual issue, giving rise to that for the purposes of ostensible authority, would be, was there a holding out? And that would then give rise to disclosure of particular kinds. There may be a series of Model C inquiries. Was there a communication from X to customers holding out Y as agent over this period of time, or about the scope of Y's authority. That's the classic approach. We don't exclude the idea that an issue for disclosure might be simply an issue of law, but ordinarily it will be expressed as a factual issue which calls for contemporaneous documents bearing upon it.
Before we go any further, an issue of law, which is the construction of a policy or a contract, inevitably requires disclosure, does it not? Because you are always looking at the whole of the document in the light of what the reasonable reader would have known at the time. And so it's not necessarily what the individuals knew, but it's the relevant factual matrix. So even in that case of an inherently legal issue, there's likely to be some disclosure.
Very often, an issue of construction won't,
But it might.
in practice of the business and property courts, give rise to
But I'm
an
not
issue
sure.
for disclosure. That was a point made by the Chancellor in the MacDonald case.
Yeah.
Yes.
I'm sorry, I don't
No,
want to
after
my
you.
lady. Well, but I'm just not sure where we're going with this distinction between issues of fact and issues of law. An issue for disclosure, I think you've now accepted, could in principle be an issue of law. Most obviously, a construction of a document, and most obviously where the factual matrix is relevant.
Yes.
And the only and that is the relevance alleged here. So, how is it helpful to say that it will often be an issue of fact? I dare say it will.
Sorry, I was giving a little background before we dive into the provisions.
Yes, I see. All right.
The provisions begin at page 572, and what your Lordship and your Ladyships have in paragraph 6.4 is a set of general considerations bearing upon an order for extended disclosure.
Sorry, so 6.4.
6.4 is a set of general provisions governing the making of an order for extended disclosure. The practice direction then gives more detailed guidance on identifying the issues for disclosure and models. And the critical provision is at page 574, paragraph 7.6. The list of issues for disclosure should be as short and concise as possible. The issues for disclosure means, for the purpose of disclosure, only those key issues in dispute which the parties consider will need to be determined by the court with some reference to contemporaneous documents in order for there to be a fair resolution of the proceedings. So if there is then a dispute, the court then needs to decide whether an issue for disclosure is a key issue in dispute, which needs to be determined with reference to contemporaneous documents. The judge at the CMC can't dodge the issue of asking whether the particular construction issue is likely to or may realistically require the consideration of background materials.
Well, I mean, to state the obvious, you've at least got to consider the contract. That's a contemporaneous document. So for myself, I'm struggling a little with what's said here. It's really a case of which contemporaneous document.
But also it's a case of what the construction issue is, because there will be some construction issues that will unquestionably not require.
But these generalities are not very helpful, Mr. Hoff. They're all obviously right, but we're talking about this case.
Yes. Well, may I then turn to McParland and say how we say that assists? And that was a case involving, it's Authorities 14, it's a case involving alleged breach of confidence committed by a financial advisor extracting a client list. The relevant passage is on page 403.
Give me a moment. Yeah.
403. And the Chancellor begins at paragraph 44 by saying the starting point is that for identification of issues of disclosure be driven by documentation that is or is likely to be in the party's possession. It shouldn't be a mechanical exercise of going through the pleadings to identify issues that will arise at trial for determination. Rather, it is the relevance of the categories of documents in the party's possession to the contested issues before the court which should drive the identification of the issues for disclosure. So we are not alone in putting relevance at the core of the selection of issues for disclosure. And then the criticism that the Chancellor makes of the...
But, sorry, can I just pause there? Is that, as I said earlier, he's really getting at the distinction between issues for trial that don't need documents and those that do.
Yes. Yes, he is.
You need to do not read what he says in that.
Absolutely, absolutely. We don't dispute that. And he goes on with the criticism he is making of the issues of disclosure in this case, which is that, for example, and this is by letter F, there is a dispute about termination. And he says, had the parties thought the point through, they would have realised that that issue is one of law construction of agreed actions, not one to which any documents beyond those produced on initial disclosure, contracts and pleaded letters and emails, will be relevant. And that's the context for what he then goes on to say. Issues for disclosure are very different from issues for trial. This is my lady's point. Issues for disclosure are issues to which undisclosed documentation in the hands of one or more parties is likely to be relevant and important for the fair resolution.
I'm sorry, I'm lost.
I'm so sorry, it's by letter H at paragraph 46.
Yes, I'm sorry, I was back at F. Thank you.
I'm so sorry.
No, it's my fault. Yes, you were in 46. I got you.
Issues for disclosure are very different from issues for trial. Issues for disclosure are issues to which undisclosed documentation in the hands of one or more parties is likely to be relevant and important for the fair resolution of the claim. Now, I'm not taking a strict point about likely meaning 51%. That is not my submission here. What I am saying is that the judge has to grasp the issue and grapple with the question of whether this particular contractual issue is realistically likely to require consideration of the background documents of the kind sought.
So yes, you're not going with 51%. You are saying realistically likely.
Well, if my use of the word likely is imprecise, I'm in good company with the Chancellor. That's what I can say. But the issue has to be grappled with, and it has to be grappled with for good reason, because otherwise every issue of construction would spawn vast disclosure of factual matrix documents, which may often be entirely unjustified.
Yes, but no doubt that's right. But what about this case?
What about this case? Let me then turn to this case and the argument based on generic issue 2, which was the core of AmTrust's argument. Its argument was that the pre-contractual communications between Sompo and insured firms could significantly influence the meaning to be given to the insuring clause and the ambit of the expression provision of services as a solicitor. We say the judge was right to reject that, making 3 points. First of all, the significance of this being a clause in standard form wording. Secondly, the significance of the critical wording coming from the SRA minimum terms. And thirdly, why the authorities AmTrust has cited, notably Encia and Quantum, don't help it. Now, the starting point is that this is a provision in a standard form contract. It's a policy wording provided to all solicitors covered by Sompo. And that means that pre-contractual communications between the parties... Do
we know that, by the way?
I can say it upon instructions that it's a standard form.
I mean, it's likely enough that Sompo or their use a standard form.
It's identical between the 3 firms, between the 3 policies we have in this case.
I mean, it's not impossible that they chose for this particular class of business to have a wording that went wider than the minimum terms.
Well, we'll come to the correspondence of the critical provisions with the minimum terms, which we will say is very close.
Well, all right, but of course, in one sense, it looks very likely to be a standard term. We don't actually know that.
It's reproduced as a standard form policy wording. It is the same between 2 separate HSS years and 1 pure year.
But that just means that for these particular clients of this particular class of business, it was the one they used.
Well,
Okay.
the other point is, and I think it may be referred to as a specific word. It is certainly page 280 under.
I suppose the reason I'm being a little bit picky about this is in certain types of context you can say that this is an absolutely standard. You know, there's some industry-wide standard, and we see we're using the such and such terms of contract. This isn't a standard form in that sense.
Well, first of all, it is a standard form in the sense that it is used with multiple insurers.
Well, with these,
It's that insurers, maybe that insurers standard terms. I think my law's making a point, for example, about market standard document ISDA and so on, where it really is a market standard.
So, certainly, I'll come to the SRA minimum terms why we say this is certainly in its relevant part, the provision of services as a solicitor, identical to the minimum terms. Now, we've made the point, I don't know whether my lord and my lady wish me to take you to them, but we have the case of AIB Group and Martin Lord Millett's classic expression that the construction of standard form contracts is unlikely to be influenced by pre-contractual communication. Maybe I should go to that briefly. It's Authorities 2, page 11 is the start.
sorry, tab 2.
So, sorry, Authorities tab 2.
Yep, fine.
Page 11. It's a case about construction of mortgage agreements under which some money was advanced to partnership and some to one member of the partnership. The question was whether a term providing for joint and several liability of the borrowers extended to terms advanced to the individual alone. And Lord Millett's dictum is at paragraph 7 on page 13. Violet at the standard form is designed for use in a wide variety of different circumstances. It's not context specific. Its value would be much diminished if it couldn't be relied upon as having the same meaning on all occasions. Accordingly, the relevance of the factual background of a particular case to its interpretation is necessarily limited. Danger, of course, is that the standard form may be employed in circumstances which it wasn't designed. It's of course not the case here. We've included in our skeleton references to this case, this court repeatedly approving this dictum, including in Lamessa and Synergy.
What sort of standard form was this?
This was, as I say, a mortgage agreement.
Yeah, but was it a standard? Was it effectively industry-wide form of mortgage?
In the headnote, it just says that it was the mortgage agreements were the bank standard terms.
I think it was the bank standard terms.
Yes, okay.
And the principle has been applied to insurance policies in a case called TKC London and Alliance. Now that was a first instance decision, but it's Authorities 20683. It was one of the catalogue of cases about business interruption insurance in the COVID era. But the passage, Lord Millett's dictum, has been repeatedly approved, as I say, not just in the context of the master agreement, but also in the context of insurance policies which are standard across a particular company's business.
Do any of these authorities deal with the question of an incorporation clause like this, where it's expressly said, for what it's worth, whatever it means, that the documents that have been seen are incorporated in the contract?
None of them deals with an incorporation clause because that form of clause tends to be particular to insurance. But as I say, I'm dealing at the moment with the generic issue 2 point. I will come to the preamble point.
Well, no, it impinges on the generic issue 2 point.
Yes.
Because you're saying, aha, therefore you don't need anything to go to that because it's all standard terms. But the incorporation clause cuts across all of this, doesn't it?
Well, we say that it doesn't add very much, picking up with what my Lord Justice Underhill said, to an ordinary argument about factual matrix. We also say that in the context of this case, as the Deputy Judge says, it begs the question of whether the particular construction issue is likely or may realistically be influenced by material which is referred to in the preamble. So
you would say professional business is a term which is defined, whatever the document said, is not likely to impinge on that. End of story.
yes, we say it was a standard expression that provision of services as a solicitor. It's been the cornerstone of the SRA minimum terms for a very long time.
You keep saying this, and
it's
it's obviously right, but the question is whether this particular kind of activity, which is the subject of the claims, falls within the definition of professional business. Surely, that means effectively whether the parties meant by professional business something that included this kind of activity. Surely it's potentially relevant to that. What the parties knew about the activities of these solicitors. And let's just assume for the moment that this was their principal business and that the insurers knew that it was their principal business. In deciding whether the parties understood that kind of business to be part of the professional, fall within the definition of the professional business of a solicitor, that background knowledge is bound to be relevant, isn't it? A fortiori, if it's background knowledge which is incorporated in the contract.
Well, with respect, we take issue with that on the basis that while in an extreme situation, as posited by my friend, communications might give rise to some sort of a stop. The argument here is about construction, and the construction of an absolutely standard expression used throughout the industry for the protection of consumers, so they know that there is an absolutely standard meaning to express to the provision.
But they don't know there's an absolutely standard meaning. There is nothing in, as I understand it, we've been shown, which says that providing the kinds of services which were provided in this case fall outside the definition of a professional business of a solicitor.
That's for the court to decide. But the meaning, what my friend's argument has been, is that the meaning of the expression provision of services as a solicitor might expand.
Well, no, not expand. I don't think you're saying it might naturally. It's a very vague phrase. I didn't understand to say, that it has a meaning, but it might be expanded by things that were said between the parties. It's rather whether in an unusual kind of business that a solicitor is carrying out, it is or isn't one that's covered by the definition of professional business.
Well, in our submission, and we'll look at impact funding in a moment, but the way that the courts have approached these in our submission correctly is to look at the terms of the contract in the context of a regulatory scheme which requires particular terms to be imposed, and then ask whether the activity which is being carried out and the liabilities alleged fall within the scope of that. Not to ask whether the scope of that expression is altered.
Well, that's the key point. You're assuming that your learned friend, Mr. Elkington's submission depends on expanding it beyond its normal meaning. But that begs the whole question of whether its meaning, as between these two parties in the particular circumstances known to them, actually falls naturally within the concept of the scope of a solicitor's business.
Let me then, in making good the point that this is a standard expression be given a standard meaning. Take, my lord and my ladies, to the SRA minimum terms.
Before you do that, if it is a standard term in the sense that it's always used by your client, but also in the sense that it's understood throughout the professional world, because it's based on what you're just going to take us to in the SRA, and therefore it is what it is, what is the purpose in disclosing your proposal and having your proposal be part of the contract when your proposal is likely to say, or might say, let's not use that terrible word likely, might say, what we're doing is dealing with this sort of scheme and ATE and all the rest of it, which would mean actually that from the very beginning, if it is not to be taken into account, the policy was useless for the vast majority of this solicitor's business.
Well,
I don't understand.
The reason that the proposal form will contain a range of questions about the size of the business, the number of partners, and so on and so forth. But if a solicitor discloses, and this, we give an examples in our skeleton, if a solicitor discloses one of the partners has a sideline in running franchised investment schemes, that doesn't mean that will become part of the provision of services.
But here
It
we've
would
got a
clearly
situ-
be, so, well, anybody should go first, yeah.
After you, my lord.
Well, but my point was simply that that's something that you would have to decide at the trial once you had seen what was disclosed.
Well, in our submission, as I say, it doesn't affect the meaning of the insuring clause.
But you keep talking about meaning.
Or the meaning of
This is about the actual question here is, does the activity in question fall within the terms of that clause? Now you can call that meaning, but that has two elements to it, not just the words, but the kind of business to which you're applying those words.
Let's put it this way. Let's just assume that the documents that haven't been disclosed explain this business. Would it really be wrong for the trial judge to have regard to that fact in deciding whether there was cover? I think you would need to say it would be wrong.
Well, certainly in answering the question whether the liabilities alleged fell within the scope of the insuring clause, we would say that the pre-contractual communications were irrelevant. Yes.
But what I know quantum is about one of the exclusions, but you've then got to deal with cases like that.
Well, Lady, I will come to that case.
Yes, I don't want to take you out of your term.
It's become somewhat the go-to case for people trying to get factual matrix in.
It may be, but he's still got to.
Well, I'm happy to join it because I said it doesn't exist.
But Mr. Hoff, I don't want to lengthen this any further. Your response to my lady was, yes, it would be relevant to the trial judge.
I heard you say irrelevant.
Irrelevant. It would be irrelevant to the question of what the scope of provision of services as a solicitor in this absolutely market standard contract means and what its effect is.
Okay.
Now, as I say, one can test that by asking the question: if a solicitor told its insurer that it was going to be doing something which was in truth outside the scope of the provision of services as a solicitor, as the courts have construed that, it wouldn't suddenly become part of the provision.
But sorry, you're saying as the courts have construed that, but you have not shown us any case in which the courts have construed.
Then I will come to that.
Okay, well, but we'll shut up for a bit.
SRA minimum terms, first of all. Authorities 27. These are the indemnity insurance rules made under a series of statutory provisions by the SRA, providing an annex minimum terms requirement. Annex 1 appears at page 750. Civil liability. Insurance must indemnify each insured against civil liability to the extent that it arises from private legal practice in connection with the insured firm's practice. private legal practice, unhelpfully, is defined in a glossary, which is under the previous tab, at page divider 24, the provision of services in private practice as a solicitor. So if we compare this against the PI policies in the present case, the structure is a little different, but the effect
I'm
is...
sorry, I can't find it at divider 24.
I'm so sorry.
Probably-
20 is divided 27, I think, isn't it?
No, but you took us back to divider 24, I think,
Oh.
for private legal practice, and then I couldn't find it. I'm sorry.
Page 719.
Or perhaps I misheard you.
The definition of private legal practice I have under divider 24, but it's...
At what page?
Means
At
the
what
provision
page?
of services in private
Private
practice
practice
as a
as a
solicitor.
solicitor.
It's right at the top of the page on page
Yes.
719. I'm so sorry.
I'm
Thank you.
so sorry. So if we put that definition together with the clause, the insurance must cover each insured against civil liability to the extent that it arises from the provision of services as a solicitor in connection with the insured firm's practice. Now, the policies gave cover for liabilities arising out of and or in connection with the provision of services as a solicitor carried on by the insured. So we accept that the in connection with words appear in a different place in the sentence. But the critical point for present purposes is that both forms of words are anchored to the same concept of the provision of services as a solicitor. Now, the significance of the minimum terms as a regulatory instrument ensuring consistency of cover across the profession was underlined in the impact funding case, in passages which, my lord and my ladies, have not been shown. That case is with authorities divided 10, page 315. And this case concerned another litigation funding scheme. This case concerned another litigation funding scheme. Whereby clients of a firm could draw down funds from a lender to cover disbursements. The lender brought a claim against the law firm alleging breach of business agreements. The Supreme Court held that that claim was excluded from cover by the trading debts and liabilities exclusion. Lord Hodge addressed the policy from page 321, paragraph 8. After discussing the policy and the minimum terms over the paragraphs that followed, he then said, noted at paragraph 15, that the texts of the policy and the minimum terms were substantially the same, with minor differences in drafting. There were, I think, some differences in the connecting clause there as well. And then over the page, paragraph 17, he addressed the correct approach to construction, this form of policy. Line 2 of paragraph 17, one must approach the construction of this sort of professional indemnity policy against the regulatory background, which aimed to make sure that protection was provided to the clients of solicitors. And then he referred to the ordinary liabilities of solicitors arising to their clients, and then noting that characteristic services of solicitors also extended to the White and Jones type case of disappointed beneficiaries. And then paragraph 18, a reader of the
And
policy,
indeed, at the end, a further category where you give undertakings to third
undertakings to
party.
the court.
Yep.
Indeed. All characteristic liabilities of a solicitor. A reader of the policy ascertains the boundaries of AIG's liability.
I'm sorry, where are you reading from now?
Paragraph 18, I'm so sorry.
Thank you. Got it.
A reader of the policy ascertains the boundaries of AIG's liability by construing the broad statement of cover, para 8 above, and also the broad exclusions in the context of the regulatory background. The exclusion in para 10 requires the reader to look to the category of claim, and in this case ask whether the claim or loss arises out of, based upon or is attributable to, a breach by Barrington of the term or terms of a contract or arrangement for the provision of the supply of services to it and also its provision of legal services. And then paragraph 29 on page 325 at the bottom. His Lordship concluded that the provision of loans to Barrington's clients was the provision of financial services to the client, but also a service provided to the firm. He goes on to give reasons on page 326, paragraph 29. And here he is applying the clause of the policy to the liabilities alleged, as we say should happen at the liability trial in this case.
But this didn't have an incorporation clause, or it did?
I don't think one is referred to,
No.
but in any event, the focus is upon the regulatory background as determining the meaning of a standard term for the protection of the
But
public.
I'm sorry to be like a cracked record. Fine, but how does that help you in this case? Unless the regulatory background shows that this kind of business is not included.
Well, we say simply that the construction of a market standard term takes account of the regulatory background, but is not altered by particular communications between the parties. Otherwise, you have a situation where the regulatory
But
background
that comes back to
applies.
the suggestion that the case against you depends on a standard market meaning being altered by the pre-contractual relations. What if it does? If the pre-contractual negotiations do not alter anything that would otherwise have been understood, but merely help you to understand what the primary scope of the provision is?
If they're not going to have any bearing on the ambit of the expression, they don't need to be disclosed.
Yes, but I'm suggesting that they do have a bearing on the ambit of the expression. It's a very wide expression. What did the parties mean by it? Did they mean it to cover this kind of business? And that's what you may get help from looking at the pre-contractual negotiations, A40 or IF Incorporated.
But the point being made here by Lord Hodgson, we'll come to what Lord Toulson said as well, is that we have here a regulator who has required a standard form of insuring clause and a standard form
Yes.
of exclusion. They have been adopted across the market.
Yes.
They are not going to change in their effect based upon communications between the individual parties. Otherwise, the public who are given the assurance that their solicitors have this form of cover will see that cover change from one firm to the next.
But why does that matter in a context where it's not being suggested that the consumer client of the solicitors isn't covered in the same way as every other would be as a result of the standard terms, the minimum terms imposed by the SRA, but in fact the parties, being the insurer and the solicitors firms, entered into a contract and they're to be interpreted in a wider way because of the pre-contractual discussions about the other activities which fit in within professional business, perhaps not, in these circumstances. You're not diminishing the comfort and protection for the consumer receiving solicitor services. You're saying actually this was entered into by parties for dual reasons.
The point we make here is that we have a set of legal principles that say pre-contractual communications will be of very little relevance to standard terms because standard terms ought not to change from one client to another. We then have the further supporting factor that these standard terms derive from a regulatory background which requires particular terms to be put in place with what I said, as I say, the I think the Deputy Judge described as a stable and autonomous meaning. The whole background requires them to be given a consistent expression across the industry.
What we don't know is whether, in fact, suppose that was very similar terms of business for very similar schemes across the industry. We don't know that that wasn't understood to be covered by this language.
Well, if
You're saying, well, we're not allowed to look at the facts of the first particular case that comes before the courts.
Well, one of the points recognised by the Deputy Judge was that there may be circumstances where the meaning of a standard contract can be influenced by wider commercial practice considerations rather than the communications between individual parties, and that was a point which had been made by Mr. Justice Jacob in a case to which the Deputy Judge referred. The point here is not that one can take account of regulatory background, which we say one undoubtedly can, or take account of what is going on across the country, but rather you can take account of communications between just the insured and the insurer as altering what would otherwise be the effect of these market standard terms. And we say that that's not going to assist the trial judge.
Right, well, we've certainly know what your submissions are on that. We better move on.
Go to what Lord Toulson says. This is page 321. Paragraph 41. This is a concurring judgment. The 2 points to highlight about the nature and purpose of the policy. One is that relevant terms replicate the minimum terms of cover the guarantor is required to maintain under the solicitors and under the insurance rules. The House of Lords recognised in Swain paramount purpose of the Law Society being given power to require solicitors to maintain cover against professional liability was the protection of that section of the public that makes use of the services of solicitors. The second and related point is that the policy describes itself as a professional liability policy, and then, like Lord Hodge, he identifies what are the characteristic liabilities of solicitors to their clients and then to quasi-clients, such as the disappointed beneficiary in White and Jones. And he then says that in laying down minimum terms of professional liability cover.
Well, perhaps we better just look at E. It refers to Jackson and Powell and says it's a developing topic and the boundaries are not entirely clear.
Yes, of course. And indeed, in any individual case, one can argue whether the provision of services as a solicitor encompasses a particular liability. But the meaning of the expression is one that is required, that is intended to achieve a consistency of cover across the market. It was for this reason that paragraph 46, Lord Toulson gave, in agreement with Lord Hodge, an interpretation and application of the policy wording, which took account of the regulatory background and the characteristic obligations of solicitors, but no account of factors particular to the individual insureds. Similar approaches have been taken in the Sutherland and Doorway Capital cases, in both of which the judges held that obligations owed to a litigation, Department of Litigation Funding Scheme were not within the scope of the provision of services as a solicitor in private practice.
Yes, I don't know whether you want to take us to those. I did look at them briefly overnight. It didn't seem to me to be the same types of obligations as are an issue in this case.
Well, in Sutherland is Authorities 19, concerned a litigation funding scheme whereby a lender alleged that the firm's solicitors had breached the contractual duty to repay disbursement funding loans if the clients defaulted. And there the judge's conclusion is at paragraph 95 on page 672, in the left-hand column in the word clause. Circumstances which have given rise to the present dispute are very far removed from the paradigm case in which a solicitor incurs a liability towards a client for breach of his duty to that client. Any liability in the Sutherland in the present case represents the coming to pass of commercial risk arising out of contractual obligation towards a party to whom Bakewell's owed no professional duties.
Sorry, which paragraph are you
Paragraph
reading?
95.
95. Sorry, yes, okay, thank you. Yep.
So once again, that is giving the interpreting the clause and applying it in very much the same way as the House of Lords applied the exclusion clause in impact, and how Lord Justice Toulson approached the interpretation of a solicitor's indemnity insuring clause, namely asking whether the liability alleged was within the characteristic range of services provided by a solicitor. Again, assuming a standard meaning for the clause. Doorway Capital is at Authorities 5. It's a decision on a strikeout application, where the strikeout was successful. Doorway Capital had provided capital to a law firm under a receivables funding agreement, provided for the firm to sell to the fund of the firm's claims against third parties, and provided for the firm to sell, and provided for the firm to pursue and collect on the claims as agent for the funder. The firm failed to pay over recoveries in breach of trust or fiduciary duty, held that the funder's claim didn't fall within the standard solicitor's PI insuring clause. And at paragraph 25 on page 107, Mr. Justice Butcher addressed the argument whether the provision of services in private practice as a solicitor included trustee-type obligations, because that was one of the sub-clauses under the definition of services in private practice, provision of services in private practice as a solicitor. And then at page 108, paragraphs 33 and 34, he rejected the notion that Doorway Capital should be seen as a quasi-client, or and that the liability alleged fell within the scope of the insuring clause, drawing upon what Lord Toulson had said in the passage from Impact to which I referred the court. So once again, the focus of construction is on the contractual words in their generic regulatory background, assuming a consistent meaning, which, as I say, consistent meaning is justified for two reasons, both because this is a standard form wording, but also because it's a standard form wording required to be used by the SRA, and in which the phrase at the centre of this dispute is a phrase which has been in the minimum terms and required to be used for many years.
Now, Mr. Hoff, I see the time, and this is clearly the core part of your submissions, which you've helpfully developed. How much longer do you expect to be? We're meant to be right that this is a half-day estimate.
Yes.
We haven't had a reply from Mr. Elkington. We might go on a bit, but we won't go on very long.
I would have said 20 minutes, but I will try to shorten it from that.
I think you have it on a bit. Yes. Well, I think you should shorten it a bit. I think by then you will have had longer than Mr. Elkington, which is slightly unusual when he had to open the case. But anyway, let's see how we go.
Let me then deal with the cases on which reliance is placed by Mr. Elkington, and specifically with Quantum. Encia we've addressed in our written argument, and it's a very different sort of case where the policy schedule positively said that the insured business meant what has been stated in a proposal form rather than having a standard rule. But I do need to address quantum because reliance has been placed on that, and that's at Authorities 16. As you heard, that was a travel insurance for a private individual who went scuba diving in a cave while on holiday and had to pay for medical treatment. The insurer disputed the claim for treatment costs in reliance on an exclusion for hazardous activities, and the issue was whether that exclusion applied. Now, on page 425, paragraph 9, we see that the policy was accompanied with an advice leaflet advising the insured to give details of various matters, including any hazardous activities they intended to engage in. The insured complied and gave notice of his intention to go diving. And then Lord Justice Waller addressed the policy terms from paragraph 11. At the bottom of the page, under conditions, exclusions and warranties, the wording said, if you are going to take part in hazardous sporting activities, including water sports activities, that present a greater risk of injury than other travel activities, you must check that your policy covers you. Sometimes such activities are excluded, and you may need to arrange specialist cover. And Lord Justice Waller then said this at the end of the paragraph: the last sentence of that advice can only be understood to mean that sometimes hazardous activities are covered, and sometimes they are covered, but only with an extra premium. And that's important because it opens the door to considering the communication. Then Lord Justice Waller, paragraph 12 quotes a general condition with at the end a reference to the insurance excluding any hazardous activity. Paragraph 14, he gives the conclusion you've been taken to, construing the policy as meaning that the exclusion is qualified to the effect that it will not apply to a disclosed activity. So the condition excluding cover for hazardous activities doesn't apply to scuba diving. So in this case, what Lord Justice Waller did was that he construed the exclusion for hazardous activities as being qualified so as not to apply to an activity notified to insurers, bearing in mind that he has previously construed the policy as involving the potential for hazardous activities to be covered upon notification. So it's a very particular sort of case.
It does say you may arrange specialist cover, and there was no suggestion that there was specialist separate cover, just that there was information about what the gentleman was going to do.
True, but what the important point Lord Justice Waller makes at the end of paragraph 11 is that the last sentence can only be understood as meaning sometimes that hazardous activities are covered. And so for that reason, he says that there can't be an exclusion for all hazardous activities. There's got to be some that are covered. What are covered? Those which have been notified. He gives the implicit qualification because of that critical step in the reasoning of paragraph 11, where he has said that hazardous activities may be covered.
But that's because the rubric at the top says sometimes such activities are excluded. So the question is, are they excluded or aren't they?
Yes.
Sometimes they're not, and sometimes they are.
So if our policy had said, sometimes we will include matters which are not within the provision of services as a solicitor, then I could see my own friend's argument based upon this case. But we are not in that territory, and what Lord Justice Waller certainly wasn't doing here was articulating some absolutely general proposition that in a standard form insurance contract, especially one with a market standard meaning, factual matrix matters will allow the insuring clause to be moulded or influenced. And this case is very particular to its facts, and as I say, that step in the reasoning at paragraph 11 is, we submit, critical.
Your time is short, and you've made that point. Yeah.
AmTrust argument based on the preamble As we say, first of all, as we say, that argument only begs the question of whether the insuring clause or the exclusion is a standard term or a term whose meaning could be altered by information. Suppose our dispute was over something like the exclusion for death or bodily injury or the exclusion for fraud or dishonesty. It couldn't be said that the preamble would influence that. So we simply get back to the question of whether the provision of services as a solicitor is going to be influenced by information given in a proposal form. The two cases AmTrust has cited on the contractual effects of preambles, Genesis and Yorkshire Insurance, you won't take them to them. They were both cases about basis clauses. Basis clauses have been swept away by Section 9 of the Insurance Act. We have made a fallback submission under the preamble point, which is one of significant practical effect, which is that information.
So what you call the preamble point, this is the fact that the documents are said to be incorporated.
Yes, my own friend's argument specifically that they're said to be incorporated. Now, what?
So that's his incorporation clause.
Exactly. Now, that refers to incorporating the written proposal and any other information supplied to the insurers. Now, as we set out in our skeleton, we say that should be construed as anything identified in the schedule as information supplied to the insurers. So documents in the information section in the schedule. We say that for three reasons. First of all, we say it's the natural reading of the preamble when read in conjunction with the schedule. Because as you saw, there's an entry in the schedule headed information with the words, the following information has been seen and agreed by insurers. We then have the preamble or incorporation clause stating that the written proposal together with any other information supplied to the insurers is incorporated. And so we say the preamble coming just a few pages later in the document is naturally to be read as referring to the information in the list, the definitive list in the schedule identified as information seen and agreed by the insurers. Second point we make is that the apparent purpose of the list is to provide a definitive statement of what information insurers have taken into account in writing the list. What would otherwise be the purpose of that information provision? And our interpretation accords with that apparent purpose. Third point is that if AmTrust were right and this preamble included any information supplied to the insurers at any time and by any means, the effect of the preamble would be hopelessly unclear. Would it refer to communication before prior year policies? If so, going back how far? Would it include oral communications with the effect of making them terms of the policies, AmTrust would apparently say? Now, if that fallback submission is right, then the disclosure in relation to the HSS policies would be more limited than the disclosure in relation to the pure policies because the list of material is much shorter in relation to those. And it could be dealt with by way of a Model C disclosure order in relation to both forms of policy. So that's our fallback submission. If you are persuaded that the incorporation point is of particular significance, we say that only the information identified as seen and agreed by the insurers.
I mean, perhaps you can just help me. I'm still puzzled by this concept of incorporation, which I think is I haven't been looking back. That is the actual word used. I don't. Is this insurance lawyers have some concept of incorporation? Is it a leftover from the days of the basis clause?
It is a leftover from the days of the basis clause. I don't need to give evidence here, but you can take something from the fact that both my learned friends' cases on this point are cases about old-fashioned basis clauses, Genesis and Yorkshire Insurance. What insurers, I understand, have tended to do is not to get rid of such clauses entirely on the basis that it might then be argued that they are excluding representations which might otherwise be relevant to the duty of disclosure, and that the change has that significance. As I say, your lordship and your ladyship can form your own conclusion as to why that clause is in there. It may assist in some circumstances. So, for example, there is a clause giving cover for prior practices defined in a particular way. And one might expect the proposal form to have a list of prior practices. which would then be taken into account. Equally, there is a clause requiring
it's a-
notification of change of risk, and the proposal form might be relevant for determining whether that's.
I suspect, though, it is the industry not really thinking things through when, in the light of other changes in practice. But there we are. Let's not spend any more time on that.
That may well be the case. On the exclusion clause, I can be briefer because I've shown your lordship and your ladyships the case law. This is an exclusion which which is in identical terms to the SRA minimum terms provision. It is an exclusion clause which has been the subject of consideration in impact funding and doorway capital, with no reference to pre-contractual communications between the individual parties. Our argument at trial will be that on the logic of those cases, the claim here falls within the exclusion. But what will not happen in our submission, what should not happen, is the meaning of that clause concerning trading debts and liabilities be altered, or its effect be altered, based upon communications between the individual insurer and insured. Now, I think in the course of my submissions I have dealt with AmTrust points under the grounds of appeal, so I'm not going to cover what was going to be part 6 of my submissions. I hope that's allowed me to cut myself down to scale a little.
That's fine, Mr. Hobb. I wasn't in any way suggesting you've been long-winded.
May I just check that there is nothing critical?
Yes, of course.
I appreciate my lord and my ladies have asked quite a few questions as we have gone along, but is there any other way in which I can assist them?
Not.
I have one question, which is in relation to the use of the phrase fair resolution in paragraph 7.6 of the practice direction. And I just want your submission in relation to what is the fair resolution of this situation where you have one party who has all the documents and the other who doesn't.
I detect a slight slant in the question, but in this case, the critical document is the standard form contract and the pleading identifying the liabilities alleged. Those materials will be before the court. The fair resolution is disclosure of material which is relevant to the generic issues. We say that is the solution which the deputy judge arrived at.
Thank you.
Thank you, Mr. Alpha. That's been most helpful. Yes, Mr. Elton, is there anything in reply?
Lord, very briefly, if I may. What we've really been hearing in argument are all the arguments that will be put forward to the trial judge as to why, for example, it's a standard for agreement not informed by pre-contractual communications, even those the incorporation clause and so on and so forth. Now, those arguments may succeed before the trial judge, they may fail, but they are all arguments for the trial judge. What we're really talking about here is what should be the scope of disclosure. And if those arguments don't succeed, the judge will want to look at the factual background, and he'll need the documents to do so. And that really covers also the fallback positions, saying, well, if you give some documents, it should only be some of them, because this is how you should interpret the information, reference to information in the incorporation clause. Well, how that should be interpreted is a matter for the trial judge. You can't decide that now, can't be decided at CMC, but what one needs to cater for is the possibility that the trial judge doesn't accept Mr. Hoff's fallback position that information is to be narrowly construed, interprets it more widely, and therefore you need further documents. You've heard lots of reference to the minimum terms and standard form agreements. The minimum terms are what they say, minimum terms. They are rules saying that solicitors, insurers providing cover to solicitors, have to provide a minimum level of cover. That doesn't mean that the cover can't be more extensive than that, and it doesn't mean that all solicitors' policies are in standard form. They're not in standard form, but they all have to meet the minimum requirements. And
it wouldn't be fatal, would it, to your arguments, if we were to conclude there was no substantive difference between these and the minimum terms, because that still begs the question of whether the minimum terms would cover what the services that your the services that the solicitors were providing to AmTech. Am I not right about that?
Yes, you are, my lord, yes, because that would still be part of the factual matrix. And you're not taken to any case which says the factual matrix is completely irrelevant and to be disregarded, even if you do have the classic form of standard form like an ISDA, where the whole market uses precisely the same document. And then you were told repeatedly that, well, professional business has a standard meaning. You referred to the Sutherland and Doorway cases, but my lord was right to point out those are very different types of obligations. And you'll remember that in the TOBAs, the solicitors expressly accept at clause 1.10 that they owe a duty of care to AmTrust. So AmTrust's primary position is we were one of the clients.
Yes, quite.
Of the solicitors. And then the last point, if I can just make it, is to you were told repeatedly, well, what professional business means has a standard meaning. But what the actual argument in the relation to the primary insuring clause is, it's not, well, what's the meaning of professional business? The way the clause is structured is whether or not, the question is whether or not Sompo can take advantage of the proviso being that the claim has to arise out of and or in connection with the conduct of any professional business. Wording which is wider than the minimum terms, entirely permissible because it's wider. And so the court will not just be asking, what does professional business mean? It will be asking, does this claim, is it a claim that arises out of and or in connection with the conduct of professional business? That either being the performance by the solicitors of services to AmTrust, to whom they promised they owed a duty, or the performance by the solicitors of services to their thousands of clients, to whom they obviously owed a duty. So it's not just a question of saying, well, we know what professional business is, you don't need to see anything else. So unless there's anything else I can help with, that's all I wanted to add.
No, thank you both very much. I think we may rise just for a moment just to see where we go from here.
Thank you.
Just to let you know, the live stream is still on.
Wait, your mum. It was one of these live streams during COVID when they didn't give you jugs, so you all had to bring your own bottles of water. So people were swigging from bottles of water. I thought, I'm not going to kill me. Really cool, swigging from a bottle. So I had to bring back my own cup at that time, so I could pour it into that.
I sincerely hope my mother has never watched it. I've certainly never.
I'm going to send her the link.
I was whispering. She couldn't hear too much about it. Come back. Hopefully I didn't follow through that.
thoughts rise in able?
Well, it seemed to us that since there is a trial date in November, there would be an advantage in the parties knowing the outcome of this appeal today. And although we can't give a judgment and won't give a judgment today, we are satisfied that the appeal should be allowed. It doesn't seem to us that there should be any difficulty about the terms of the order. Effectively, you will get what you asked for in your version of the disclosure review document. I think it would be helpful if, therefore, if a draft order could be submitted as soon as possible, allowing the appeal, but also making clear what order, therefore making the substantive order that you asked the judge for. And there may be, there may be one or two consequential matters on which we will deal in our eventual judgment. But I think it will help the parties to have an order now. I'll come back and give you the usual formula about the handing down of the judgment in a minute. But so far as the order is concerned, is there anything else we ought to be thinking about while we've got everyone in court?
The order will have to make provision for when the disclosure is required by, because the bulk of the disclosure has already been given.
Yes.
Leading to trial. But I'll take instructions on when that can be done. The parties will attempt to agree. I can't imagine it will pose difficulty. Equally, there will need to be provision in the order for the parties to agree within section 2 of the DRD searches and so on, in order to give effect to issues 1A and 1B, which are now being added. Again, parties have done well so far in this litigation in agreeing that sort of thing, so I anticipate that we can agree those. There may have to be a provision for disclosure guidance.
Yes.
in the
Well,
version
we won't. Formally, the order will only be made when we make it. You know what the substance of it will be. Within reason, we'll give you. We won't say come back this afternoon because there may be a bit more discussing to do. Unless we get a reasoned request. What's today? Today's Tuesday, isn't it?
Tuesday the 10th.
Yes. Well, can I suggest that we have a draft by close of business on Thursday? That ought to give you enough time. If there are difficulties, you can always come back, and we will be sympathetic as far as a good reason is given. But I'm confident, having seen the way the background to the case, the way it's been argued, that professional solicitors and counsel on both sides should be able to agree those sorts of points. The worst comes to the worst, there's some real dispute, we'll deal with it on paper.
Could I just check one point on the issue? I'm just checking that issue 1B is to refer to both policies. It was something that had been agreed prior to the CMC, because for HSS there were 2 policy years in question, but when the issue for disclosure was drawn up, it only refers to one of the 2 policies.
We took it as referring to both, and there won't be any issue about that.
Well, that's helpful.
Thank you.
Well, then, and the order will therefore also include a recital of having to hand down judgment with the reasons to follow. The reasons will follow. We'll hope to do them fairly promptly, but as I say, we didn't want to write the judgment under great time pressure, and it's helpful for the parties to know where they are now. They will be circulated in the usual way. Having kept everyone, including the shorthand writer, so long, I won't give you the full standard wording about confidentiality. But if you want any guidance, you'll find it in the Counsel General for Wales, case. We are most grateful for very helpful and effective submissions from both parties, both on paper and in writing, and grateful to those behind who I'm sure contributed. and grateful, as I say, to the shorthand writer. I think you're going to get transcripts, and we'll get. Can we have them as well as soon as they're provided? Good. Thank you very much.
Cauterising able.